And Megan Fox here at PJ Media is explaining.
What's tip 4?
Well, don't trust women. I think you just touched on that with your Dancing with the Stars.
You can still love me.
I do. I love you all the time.
Our First Amendment rights are huge. They are very important to me. They should be important to everyone.
Don't be a public official if you don't want to be filmed, ma'am.
Megan Fox.
Yes. Hey guys, welcome. It's me. It's Megan Fox. I hope you can hear me okay. I'm being quiet. I'm being very quiet because Mr. Fox is asleep just beyond the next door. He's been sleeping. I'm on the porch. He's been sleeping on the couch because I'm still coughing in the middle of the night, keeping him awake. So I'm trying to be quiet. We are going to watch Dr. Chopra Part 2, and we're doing it now. I'm on the porch, so disregard the traffic noise. I'm going to mute myself when I share the trial stream, but let's get back to Dr. Chopra from the Maya stream. I have the camera turned off because it's super dark out here, so the lighting is terrible, and I'm in my jammies, and I'm in my gym jams, and I'm drinking my apple whiskey sour, and I just don't feel like being on camera, and that's okay. So here we go. We are going to go back to the trial where we left off when I made my red pepper soup, which was a huge hit with the kids, by the way. They loved it. They ate almost all of it. I'm so bummed. All right, here we go. They're just coming back from the break.
How are we coming?
Oh, I'm sorry.
I'm here. That's okay.
Did he really say, "I'm sorry, baby"?
I don't want to interrupt. I just kind of figure out.
Judge, can you flip it on? I want to show you. I messed up. When we were having that colloquy there, I should have remembered the report. The report lays out an entire life care plan over the course of 2 pages, and I wanted to show it to you if you don't mind.
That's fine.
Okay, so if you go up here.
You just highlight it, the area.
Yes. Next page. Okay, beginning with considering the complexity of the condition.
Down. I need to turn it off and turn it back on so the gallery comes back on.
Okay.
I for whatever reason, sometimes those gallery TVs just don't like coming on. There we go.
And then on down from there, continue down, highlighting to the bottom, and then the start of the next page, please.
Doctor, can I actually ask you to step outside for just a couple moments? Sure. Thank you, sir. No, I'm just waiting for the doctor to get out of our presence. The transcript will reflect the doctor's out of our presence at this time.
At this time, Your Honor, I would like to continue direct examination. For the record, when we had a colloquy about the scope of the doctor's opinion, I had focused on the deposition, completely forgot about his report, which is Exhibit 2005-1 through 32, something like that, 21. And in that, there is not a life care plan, but all of his recommendations to a reasonable medical probability of the care and treatment for Maya Kowalski based on her symptoms and his diagnosis. If you go to the next page, please. 19 or 20. And so there he goes on. Also demonstrated positive results of physical therapy. Treatment Dr. Hannah specializes. Basis for diagnosis, much of mine is incorrect. She does not meet the criteria. I don't need that, but from that point up, and then the page before.
Mr. Anderson, I looked at it. Let me hear from Mr. Shapiro.
Yes, sir.
I guess I don't know what they're intending to do. Just the basis for just to be clear, this is a plan that he had for Maya after one visit on January 22nd, 2017. The question to him is simply, did you have a plan for Maya's care you can walk through it, but that's different than saying as a result of the mistreatment that you allege at All Children's Hospital, do you believe within a reasonable degree of medical probability she has these future problems? That was the basis of my objection because, again, in his deposition, I believe, clearly disavowed any future care opinions because he hadn't seen her. But I don't object if he just wants to continue this direct and ask him about what his plan for the patient was on that day based on his exam.
Well, my recollection of the questions that were asked that we had the sidebar conversations on or multiple sidebar conversations on, and my sustaining your objections, the concept was that it was an undisclosed opinion that neither in his report nor in the deposition was there discussion of future, whether it was care and treatment or a future opinion. But this report suggests that he did, in fact, have opinions about future care. And so at this point, I'm going to reverse my rulings and I will allow the questions that Mr. Anderson had previously asked, to which I sustained. And the plaintiff can continue in direct when we are in front of the jury.
Thank you, Your Honor.
Do you mind if I just get a quick point of clarification, respectfully, Your Honor? And I don't know if plaintiff intends to do this. Does this court find that merely because Dr. Chopra had a plan on this date for several things that he wanted and that his patient to undergo, that would open the door for him to then talk about life care plans in the future as a result of negligence, or just merely that he can discuss what the plan is?
What I was just seeing on the screen was talking about future items. So, certainly I don't know what the doctor is going to say about future items. If it's beyond this, maybe that's going to be an issue, but it's clear that he had a forward-looking report that was presumably available to the defense. And as such, I think it's fair game at this point. And that was the basis of my objection, was it was undisclosed, but it seems like it was, at least in part, if not in totally, available to the defense and understood that that's what this doctor was going to be saying.
And just a last point of clarification, respectfully, the objection the defense is making is any testimony about future care related to future damages, as opposed to, and I don't have an objection to him talking about in his report, his future plan of care for the patient. I think those are two different separate categories. Mr. Anderson may not be going back theirs, but I will make the contemporaneous objection.
I think you need to make the contemporaneous objection, and it may be that it is beyond his deposition and his report, but I think I need to actually hear the specific question at that particular point in time and the specific objection. Are there any other issues we need to address?
Your Honor, we had done a request for judicial notice, which the court granted on trial exhibit 23021 and 2301.
What is?
And those are, I've got copies real quick.
Can you just put it up so I know what you're talking about?
My intention, these are House resolutions regarding reflex sympathetic dystrophy month, and there was one in 2004.
What are you trying to do with a legislative resolution?
I am asking the witness to identify this and asking whether this is further evidence that the doctors at Johns Hopkins should have been aware of the problem of misdiagnosing exactly what they were diagnosing.
I'm unfair. You're asking a doctor from Rhode Island to comment on a resolution by the Florida House of Representatives?
Well, he is licensed in Florida as well, and it's a relatively minor point, but I think it is.
Has he been in the Florida legislature?
Not that I'm not aware of.
My recollection when I handled this before was, I'll take judicial notice of it, but as a matter of evidentiary fact, that me taking judicial notice does not make it an evidentiary fact. I think that's how I ruled, I don't know, 2 or 3 months ago.
I agree with that. That's what I think. That's what you said.
And I don't see this witness being able to talk to us about what the Florida House of Representatives has done.
I'll save it for cross or something else and I'll bring it up again.
Anything else before we bring in the doctor?
Not from the plaintiff.
Let's go get Dr. Chopra, please. Okay,
I'm-
welcome back, Doctor.
I'm trying to be
Just to
quiet.
let you know, when we bring the jury back in, since we've had this break, I'm going to remind you that you're under oath. I'm going to do that in front of the jury. Sure. Just let you know I'm going to do that. Let's bring in the jury.
I'm trying to be quiet when Mr. Fox is sleeping, so I'm going to sound like a golf announcer. And the jury is coming back into the courtroom as we speak. Maya is looking very tired. Yeah. I'm sure this is emotionally taxing.
Hey, everyone, please be seated. Okay, members of the jury, I want to confirm while you were away, you did not discuss this case amongst yourselves. You did not do any investigation and you received no information. Is that correct? Yes. I also want to confirm that and ensure that no one approached you about this case since we last were together. Is that correct? Correct. And that you have not seen any media coverage about this case since the last time we were together. Is that correct? Correct. Thank you very much. Mr. Anderson, you may continue your questioning, sir.
I'm back.
No. Sticky tape.
Before we broke, there was a series of questions concerning Maya's future care. And I'm allowed now to ask you about them. And I want to reference you to your report of January 22nd, 2017. And with the court's permission, I have it published here, previously discussed it. Can you go through this? You don't have to dwell on every one of them, but I want you to name off for the jury here the various treatments and the reason why they are reasonably medically necessary for Maya, given her aggravation from CRPS.
Same objection.
So one of the things about treating CRPS is that I do is I know the definition is everything else has been ruled out. So the patient has severe excruciating pain and everything else has been ruled out by definition. That's the definition of CRPS. But I still look for a cause. Maybe there is something somebody missed, or there is something that I can find, and that would be obviously magical, because then if you know what's broken, we can fix it. So in her case, I looked for a condition called Ehlers-Danlos syndrome, or in brief, EDS. It's a kind of a benign condition where your joints are loose, you're hypermobile, and she had some features of that. Now, I wasn't sure about it because at that time, this was back then, there were no guidelines on how to diagnose this condition. It was actually in 2017, later on, that the guidelines came out on how to diagnose it. So I just put that there, that later on in the future in her life, she might ever want to explore that, she can do that.
Next one.
The next one was, I said that she meets the criteria for complex regional pain syndrome.
And then let's go to 3. I think we covered that.
So in number 3, I talked about a condition called tethered cord syndrome. And this is actually a condition common in children, and it is common in patients with Ehlers-Danlos syndrome. And in this case, what happens is that these patients have their spinal cord is not hanging loose in their spine. It's tethered to the bottom of their spine. And it's a congenital condition. And oftentimes these patients can present with pain in both their legs. And it's a neurological condition, and it is diagnosed by a neurosurgeon. I also put that in there because maybe she has it. Maybe we need to do a further workup. We don't know.
Okay. And we go to the next one then. 4.
Are we going to magnify?
Let's see. 1, 4. I don't need to cover that one. I was really interested in the CRPS treatment on the next page. Okay. Now, beginning at number 5, if you could go down and let me ask you the question. From 5 down through, I think then there's more on the next page. But these from 5 on down, are these reasonable and necessary medical condition treatments for Maya Kowalski based on the aggravation of her CRPS to a reasonable medical probability?
Yes, these are reasonably necessary, absolutely.
So let's give the jury an idea here of we've talked about things that she can look into in case, but let's talk about what you think she should be doing or the treatment she should have.
Based on my
Your report, which is in
okay, so
evidence.
on number 5, I put in there recommend physical therapy for upper body strengthening exercises. So here's the thing: when she got her initial ketamine at Dr. Kirkpatrick's office, her upper body pain actually improved. The pain in her arms improved, but not the pain in the legs. And so, she was, when people use a walker, they need upper body strength because that's what they're supporting themselves on. They need to have stronger arms, stronger upper body. And so I said, all right, let's strengthen what we can strengthen. And at least so she can, hold the walker and walk. So that's what I said.
And how much, as she continues in life, should she reasonably expect to attend or go to a reasonable medical probability in order to minimize the effects of the aggravated CRPS?
Well, to minimize she has to completely avoid aggravating her CRPS.
Let's assume in life there is aggravations now and again. How is the physical therapy? Should it be periodic, or should she continue to attend physical therapy throughout her life, so long as she has the symptoms to a reasonable medical probability?
I need to clarify that.
Sure.
I actually said to hold off physical therapy for her legs.
Right.
Because you cannot do physical therapy on someone who has excruciating pain in their legs.
Right.
Okay, that's it. So for now, just strengthen the upper body, control the rest of her pain in her legs, which had been aggravated by her whole episode at the ACH, and then work on the legs.
Okay. As she has, and to a reasonable medical probability, is Maya going to have relapses from time to time of varying degrees and types?
Yes, she is. Okay, let's talk about the relapses for a second. This
Sure.
is not a joke. We're not talking about relapse of a little headache. We are talking about severe. She lives at a baseline pain that you and I cannot even comprehend. Okay, that's baseline pain. Her brain has now changed enough that she is okay with that pain. When she has an exacerbation, it's horrible.
And are you aware, or has that come to your attention, that she has in fact had a relapse in November of 2020 that put her in the hospital?
Yes, I know that she did, and I don't know what happened. It may have been some sort of a stress. I know she didn't have an accident or a physical fall, but
Okay.
it could have been some stressful event that could have triggered that.
And her already having had a relapse, 2.5 years, 3 years after getting out of Johns Hopkins, does that have an effect on your opinion that she may have more and longer and more aggravated relapses through her life?
It's the same, it's the same analogy I gave you. If you have a wound on your arm and before it heals, you whack it and it breaks down, the skin breaks down again and the wound becomes worse again. And if you keep continuing doing that, one day it's never going to heal. One day you're going to be left with a really terrible open wound on your hand. And that's the same thing with this. If you keep aggravating her CRPS, her brain is finally going to alter itself. If it hasn't done it now, it is finally going to alter itself. That is that her CRPS will never, ever go away. It never goes away. It gets we use the word remission, where it kind of comes down a little bit, enough that they can function.
And I believe you testified to this before, but just to tie it in, do you have an opinion based upon your background, training, and experience, and to a reasonable medical probability, whether the timing and the intensity of what she experienced at Johns Hopkins over those 3.5 months aggravated that CRPS so as to cause her extra injury and damage?
So, I need to give you the bigger picture on this.
Okay, go ahead. I just wanted to, yes, you do have an opinion or no?
You need to add $2 there. So, I'm going to make money today. So here we are, so we have a 10-year-old girl and she's got CRPS in her legs. Okay, but her mom's frantically running around all over the country from Chicago to Tampa looking for treatment for her. Okay, she finally finds Dr. Kirkpatrick. He does ketamine on her. It helps her partially. It helps her arms. Okay, we got a little win there. But then he says, look, you need much more than what I can give you. So you need to go to Mexico and see Dr. Cantu, who's going to give you a ton of ketamine. And she does. And she comes back and she does well.
Mhm.
And in fact, she does so well that Dr. Who's the doctor from?
Hannah or
No, there's a doctor
Cantu?
from Johns Hopkins, the pulmonologist.
Kreisman.
Kreisman.
Dr. Kreisman.
Dr. Kreisman and her pediatrician said, this is not the same girl. This is a different girl. Her skin lesions were gone. She was a whole different girl. They both commented on that. And then obviously you can't afford treatment in Mexico that long. It's expensive. So she did the next best thing was to go to Dr. Hannah, who tends to use higher doses. And so it was some sort of an agreement that she made. And she started to do ketamine with Dr. Hannah at somewhat higher doses. And she was doing great. There are videos of her swimming, running around, playing, doing great on with physical therapy after Dr. Hannah's treatment. So you can see the progression that from a lower dose with Dr. Kirkpatrick to a higher dose with Dr. Cantu, and then to Dr. Hannah, she is starting to make progress. Now she has this abdominal pain, goes to Johns Hopkins, and then everything goes down the drain. They don't believe her. They don't treat her stomach pain. They don't take care of her CRPS. They don't even, and she's been there dozens of times before. And now they treat her like they've never seen her before. They don't believe her. They stop all her treatments. And not only that, they mistreat her by keep touching her, keep handling her, and her CRPS flares up back to where it was.
So is that, I guess, Johns Hopkins did aggravate her CRPS so as to cause her more damage and injury in the future?
Yes, very much.
And so let's continue down here. You've had, exercise and joint protection. I think you've talked about, avoid desensitization, avoid sensitization exercises. What's that about?
So, one of the theories in CRPS is that, all right, if because your arm is so sensitive, I'm just taking the arm. If your arm is so sensitive and if you have CRPS there and touching it makes it painful, we are going to touch it even more. We'll take a rough towel or a sponge or something like that and rub it even more so that your brain gets used to it. Okay, now that philosophy is actually counterproductive because do you remember how I said this morning that a barrage of pain signals, if I took a pen and I stuck it in my finger again and again, there would be a barrage of pain signals to my brain. And then the brain then alters itself. And it now takes over the pain. And this is what will happen when you do so-called desensitization exercises. If I take a rough towel and I start rubbing it on the area of CRPS, you are sending even more signals up there. There is zero literature. I am not kidding you. There is zero literature on the benefits of desensitization. I have searched it everywhere. I've asked people who do this. I said, where did you learn this from? Where is it? No one knows. So,
Doctor, why don't we wait for the next question and then you can answer?
You owe me $1 back.
oh, sorry.
No, the question then is, can you describe for the jury then with more specificity, is she going to have more of these relapses than she would have had she not been interrupted in her first round of care?
Yes.
Will they be more aggravated when she has them? That means more painful, more debilitating. And third, will they be in terms of length longer? So the three again are: is she going to have more number?
How about one question at a time?
Yes, sir. You get my question?
Yes, to answer your question, yes, she'll have more frequent incidences of CRPS because the treatment that was initially working for her was interrupted.
And will those episodes be longer in length than they would have been, or will have any effect on that?
That's a slightly difficult question to answer.
Fair
Some will be longer and some may not be that long.
But can you tell us when she does have them, are they going to be more intense than they would have been had she completed the therapies that were in place?
Yes, every exacerbation she's going to have is going to be a lot more intense.
So she's going to have a lot more and more intense, but there's no way to tell the length of them. It's just a summation. Okay. Now, well, we haven't finished this. Doctor, I don't want to take a whole lot of time because it's in the report, which is in evidence, and so you can read it. They can read it for themselves. But generally speaking, can you tell me? Can you tell us? I'm going to stick step ahead here to number 10, gastroenterology, and why that's important.
So when I talked to her, and I went through every system, and when I got to the stomach, and I asked her, "Do you get bloating when you eat?" And she said, "Yes, absolutely, I do get bloating when I eat small amounts of food." And remember, she had already been to Johns Hopkins twice. I think, as long as I remember, it was twice for belly pain. And what happens as a complication of CRPS is the nervous system that controls the movement of your intestines. So your intestines move like a toothpaste. Okay, so when you eat food, it moves along like a toothpaste, and that is controlled by a nervous system called the sympathetic nervous system, and that is affected in CRPS. And that was the reason her food was not moving, and obviously it was collecting, and she was starting to have all this abdominal pain, belly pain, and she was getting malnutrition because of it.
All right. Then is there a number 12 there? Or have we reached the end? It says under 11A, it was minimized trauma. I think you've covered that. And then we go on the next page to continue on to the top, please. I think there's more. Go up. Here. Vitamin C exercise program, trial of graded motor imagery. What is that?
So there was a research that came out of Australia. It's actually accepted research modality for treatment of CRPS.
Sustain that objection.
What was the objection?
Bolster.
Oh, okay. Just tell us what graded motor imagery is, the basics.
It's in 3 parts, and the 3 parts I mentioned over there. It's a kind of an exercise you can do at home for people who have CRPS in one limb.
And then you said an echocardiogram, is that periodic under number 12?
That's if she has Ehlers-Danlos syndrome, then an echocardiogram is a standard practice.
All right. And then, okay, positive results of physical therapy. So should she keep up physical therapy throughout her life as she's done?
Provided her pain is controlled.
Right. What about medications? Do you have an opinion based upon your background, training, experience, or reasonable medical probability if from time to time she would benefit from medication?
That's a difficult question to answer because her mother had tried a lot of medications, but that was a different time. And so we don't know if she can try them again, but she will need to try different medicines.
And with based on the assumption that the relapse occurred some 2.5 years after she got out of Johns Hopkins, do you have an opinion to a reasonable medical probability that the opinions you have offered here are equally applicable for this jury today?
Can you rephrase that?
That was a very good question. To a reasonable medical probability, is your report here in 2017 applicable today, these different treatments and future medical care?
Yes.
So just a couple last questions. I think the jury will hear at some point about intrathecal pumps and Beata Kowalski's request, or just asking about it in theory. But what is an intrathecal pump, and is this some boogeyman that we should be afraid of? All right.
Why don't we just go with it?
What is the pump?
Intrathecal pump simply means a pump in the spine. So the principle is actually amazing. And I'll give you an example. If a person needs, say, 10 milligram, needs morphine, 10 milligram pill for their pain by mouth, 10 milligrams by mouth. If you give the same morphine into their spine, they'll only need 1 milligram, which means they need lower doses. It is far more effective because you're hitting the pain at the source, and you're also not seeing any side effects. So intrathecal is in straight language, it means spinal pump.
And from your experience with mothers and fathers of children with this extreme pain, do you find it in any way unusual or odd that she would question whether the intrathecal pump would be appropriate for Maya?
Yes, it is an appropriate request. I thought it was an amazing request that she made it because she's trying to decrease the dose of drugs that Maya is getting.
Mm-hmm. All right. And finally, is ketamine FDA approved for children?
Yes, it's used all the time for children.
And is it now FDA approved as what's known as an orphan drug?
Yes, it is.
And what is an orphan drug?
So actually the sentence should be, is it approved as an orphan drug for CRPS?
For our CRPS, my apologies.
Yes. And so, there are some diseases that, like the FDA has these rules. Okay. Like they might say somebody with migraines, we need, a million patients. We need you to test this drug on a million
Objection
patients.
is hearsay on the FDA rules.
Well, I'm just trying to
You,
explain.
you can answer that one.
You can answer.
But in some diseases that are not that common, they can't get a million patients with CRPS. So the FDA says, all right, we let you do it with 400 patients, and that's called an orphan drug use. So they kind of make it. They're not all diseases are that common, and some diseases that are not common, they put them down as orphan drug use.
Is that because of the expense of doing a full trials?
No, it's because they can't find that many people.
Okay. And I have to ask you one last question on reliability here. Do you have an opinion based upon your background, training, and experience into a reasonable medical probability from everything you've seen here, whether the doctors comprising the Johns Hopkins pain management team, that is Laura Vose, Richard Elliott, Amish Patel, and nurse Ashley Sumner, breached a duty of reasonable care by deviating from the accepted standard of care insofar as the care and treatment of Maya Kowalski?
Yes.
Overruled, the answer stands.
And can you tell us to a reasonable degree of medical probability based upon your background, training, and experience, whether that was a cause of this aggravation and this future we now know about for Maya?
Can you explain that a little bit?
Sure. I want to know whether when you answered about they breached a duty of reasonable care, was that breach a cause of the damage and injury to Maya?
Yes, it was.
And is that your reasonable medical probability?
Yes.
Your witness.
Mr. Shapiro.
Good afternoon.
Good afternoon.
Were you aware that Beata Kowalski chose you?
No, I had no idea.
First time you're learning about that today?
This is the first time I'm hearing this.
Okay. You're not an emergency physician, correct?
No,
You're not board certified in pediatric anesthesiology either.
no,
You, in terms of hospital privileges, you haven't had any in more than 20 years, right?
I chose not to.
Okay. You don't treat patients in hospitals.
I don't have the time to go to hospital.
Okay. In terms of your fees to be here, what are you charging?
Sorry, could you?
What do you charge to be here?
Oh, so far they've been kind enough to pay for my hotel. The rest, I have no idea.
Okay. You haven't sent a bill to Mr. Anderson yet for your time?
No, I haven't.
Okay. Do you know what it will be, or you haven't tallied it?
I have no idea. My office handles that. I don't handle that.
Okay. I know you don't know the amount, but just so it's clear, Mr. Anderson, his office is paying you to be here today and for your review. Is that fair?
They're paying for my time.
Let me ask you about ketamine. You told the jury a moment ago about FDA approval. Back when Maya was getting ketamine in 2017, ketamine was not approved by the FDA for CRPS. True?
Well, yes,
That's true.
that's true.
I want to talk to you a little bit about your statement that Maya was improving before she went to All Children's in October of 2017. You base that on your review of Dr. Hana's records, right?
Actually, I based that not just on his records, but also on videos.
Okay. Well, let me see if I can narrow down a time frame here. Clay, will you put up what's in evidence as Joint Exhibit 1040-206? And you can enlarge this. I will represent to you, we can go to, this is a signed letter from Dr. Hana dated September 25th, 2016. Do you see that?
Yes.
I'll represent to you that this was written by Dr. Hana to the school district to explain homebound status. And I'm going to ask you about some of the statements in here to see if this is consistent with what you're telling the jury in terms of how Maya was actually doing before she went to my client's hospital. At the top, it says, Maya suffers from horrific disease, RSD, CRPS. Do you see that?
Yes.
Your testimony to this jury is before Maya ever went to my client's hospital, she had debilitating CRPS. That's what you believe, correct?
Yes.
And as a result of her debilitating, horrible CRPS, she was going to require, in your mind, a lifetime of care. True?
Yes.
Okay. Now, reading down on this, it says on September 6, 2016, evening time, Maya had a relapse of her RSD. Maya became overstressed, extremely worried, and crying after a September 6, 2016 individual education plan meeting at Taylor Ranch School, which I strongly believe led to her RSD relapse. Do you see that?
Yes.
Okay. Did you know, and maybe you didn't, but did you know what caused this alleged relapse of RSD?
Well, it says right here,
Okay.
after the IEP meeting.
So at least from your understanding reading this record, there was a psychological stress on Maya that you would attribute to the relapse of RSD. Is that fair?
A stressful event at the IEP meeting.
According to this letter, Maya was then complaining of severe pain to her legs, 10 out of 10. True?
True.
She was complaining of severe pain to her back, 10 out of 10. True?
True.
She was complaining of severe pain to her arms, 9 out of 10. True?
True.
Severe pain to her stomach, 9 out of 10. True?
True.
Migraine pain, 10 out of 10. Correct?
Correct.
Severe weakness, nausea, and vomiting, and was unable to eat or drink fluids for 3.5 days, leading to her dehydration. True?
True.
And all of that was a couple weeks before she entered Johns Hopkins All Children's Hospital on October 6th, correct? October 7th, I apologize. I mean,
Yes.
this was her condition. And in addition, because you were telling the jury how well she was doing, I want to make sure that you understand this letter. Maya also required daily IV fluids for hydration leading up to her hospitalization at All Children's. True?
Well, this needs clarification. You can't just say true.
Well, do you have any reason to dispute what Dr. Hanna wrote to the school board saying that starting on September 6, 2016, Maya, on a letter dated September 25th, so now 3 weeks later, that Maya was requiring IV fluids for hydration? Do you have any reason to dispute this?
No, I have reason to dispute a lot of this letter because, you see, she was doing well. And then she had this IEP meeting on 9/6/16, and obviously that was a stressful meeting. And she went down. Everything, her condition got worse. Now that's a feature of CRPS.
But my point, doctor, is she never got better between this September 9th, 2016 relapse that you're claiming is a relapse of CRPS until she went to All Children's on October 7th. You recognize that, right?
No, I don't. How do you know that she didn't get better?
All right, let me show you the next record. Well, before we move on to this, the second last sentence says, as of September 15th, 2016, Maya K's RSD relapsed, and she has not returned to her usual baseline where she used to be prior. Do you see that?
When she used to be prior to 9/6/16. Okay, yeah, I do see that.
Okay, so now let me ask you about what's joint exhibit 1040-20. This is in evidence Dr. Hanna's records. Joint exhibit 1040/20. And if you can zoom into the top on the date, this is October 5th. So now, if you want to clarify whether Maya was better before she walked in the hospital, I'll represent to you, this is now 2 days before Dr. Hanna asked her to be admitted to All Children's. So let's scroll down a little bit more. Do you see on the history of present illness in capital letters, patient stated that her weekend was rough and she didn't sleep due to pain and had a great deal of nausea and vomiting. Do you see that?
Yes, I do see it.
And on the weight chart, 2 days before she went to All Children, she was 60 pounds. That's the 5th percentile. True?
Yes,
And her height was below the 1st percentile. Do you see that?
yes.
Do you know from your review of the records that Dr. Hanna then infused 1,250 milligrams of ketamine?
This was the day before she went to,
2 days before.
2 days before she went to All Children's.
Correct.
Yes, I know that.
Do you actually know that she underwent 5 ketamine infusions in the days leading up to going to All Children's?
Yes.
Let me ask you, Clay, if you'll turn to Joint Exhibit 1040/233. Were you aware that Dr. Hanna had his patient Maya fill out how she was feeling in her overall, what they call quality of life survey?
Okay, so I'm not just going to say yes to this.
Well, let me ask you this, and then if you need to explain, you can. You're aware of something called the American Chronic Pain Association Quality of Life Scale, correct?
Again, this is not an accepted quality of life scale.
Okay. Well,
This is by an association that doesn't mean anything.
okay. Well, the question, you can see there's 0 through 10, where they're asking Maya, How are you feeling with 10 being go to work, volunteer each day, normal daily activities each day, have a social life outside work, take on an active part of family life? That would be 10, normal. 0 is stay in bed all day, feel hopeless and helpless about life. Were you aware that 2 days before Maya went to All Children's, her function was 0, according to the survey? Were you aware of it?
Right, and that's expected of it. A 10-year-old child with excruciating pain everywhere is going to be, she doesn't see anything left in her life because she's in excruciating pain all the time.
Let me ask you about Joint Exhibit 1040/17. Were you aware that even after this, Maya went back to Dr. Hanna the next day for a large IV ketamine infusion? Were you aware of it?
Which date is that?
This is October 6, 2016, the day before she was admitted to All Children's. Were you aware she was up in Clearwater getting a ketamine infusion from Dr. Hanna?
Well, I do see the record, so I'm sure she did.
Okay. And in fact, at least the time of the record is 3:40 p.m. I'll represent to you she was admitted to All Children's the next morning. But according to the record, again, it says on the history and physical, patient in mother state, patient is still in extreme pain. Do you see that?
Yes.
And then Clay, I'll ask you to go to Joint Exhibit 1040/225. This is the quality of life survey filled out the day before she went to All Children's. It was 0 again, wasn't it, doctor?
That 0 is going to be there for a long, long time.
You expected this 0 to be there for months, didn't you?
Listen, if you have the world's worst excruciating pain and you're a 10-year-old kid, let alone if you had it in one leg, you would be still 0. She had it in 4 limbs. She is always going to mark that 0 at that point.
But certainly what you're telling this jury, it sounds like, is based on her condition the day before All Children's, Maya was going to be sick with crippling pain for a while, correct?
She's going to be sick with crippling pain for most of her life.
Right, including through her hospitalization at All Children's. That's what you think. Not because of what All Children's did, because that's her condition.
Right. And she did not respond to the ketamine that given to her 2 days before that, and then she had abdominal pain. And that was the reason she went to All Children's.
Because the ketamine failed, correct? The ketamine.
That episode failed.
Okay, let me next ask you about some of the things that went on in the hospital. And before I do, let me just ask you this. You use ketamine. You do not, in your practice, recommend ketamine comas, true?
I don't do ketamine coma in my practice.
Okay. You don't do hyperbaric oxygen therapy?
No, I don't.
You don't do oral ketamine?
I do sublingual ketamine, which is under the tongue. You put this ketamine under the tongue. You don't swallow the pill.
You don't drink oral ketamine with Gatorade for your patients, do you? You don't have ketamine mixed with Gatorade and have the patient drink it at home, do you?
I don't believe in oral ketamine.
Okay, let me ask you, before we move on to what happened in the hospital, you do recognize there is authoritative literature in the field of ketamine infusion, true?
Objection.
There is a what of
Hold on a second, doctor. What's the legal basis? Improper impeachment regarding literature.
Well, I'm asking him if he can, so I'll rephrase the question. For infusion of IV ketamine for CRPS, are you aware of consensus guidelines?
Yes.
And do you consider those guidelines authoritative in your field?
I'm sorry, consider what?
Do you consider those guidelines?
Yes.
And do you consider those guidelines authoritative in your field?
I'm sorry, consider what?
Do you consider those guidelines authoritative in your field?
No.
Okay. Do you remember when I took your deposition on February 25th, 2022? I'll hand you a copy. I'm going to ask you to turn to page 37. If I may approach it.
You may. Sure.
This is a copy of your deposition that I took.
Page 37.
Yes, page 37. And on line 15, I asked you, for the infusion of IV ketamine for CRPS, are you aware of any consensus guidelines? And your answer is yes, there is one. And I asked you, do you consider it authoritative in your field? You said yes. Well, it is authoritative.
Well, I wasn't referring to the one you're referring to. You're referring to Stephen Coyne's.
The one attached to your deposition. I asked you, was that authoritative? We marked as Exhibit 9 to your deposition. Are you saying you no longer recognize it as authoritative?
What's attached to my deposition?
I'll hand you the other.
Huh?
We're talking about the one authored by Dr. Stephen Cohen, correct?
You're talking about that, not me.
Okay. When I showed you Stephen Cohen's article in your deposition, you told me it was authoritative per your testimony, did you not?
I don't recall seeing Stephen Cohen's, because I've never believed in those guidelines.
Okay. Well, let me ask you about some of the care that went on at All Children's. You were aware, well, let me just ask you about, you reviewed the records from All Children's, true?
Yeah, 7,000 pages.
Okay. Let me ask you about Joint Exhibit 1001-2718. At the bottom where it says result comments R46, the second paragraph, did you review this record? Patient also stated in the room with me that she hasn't eaten in 5 days. I asked her if she doesn't have an appetite, and she said she can't eat because she's not allowed. Did you review that record?
Listen, there were 7,000 pages, so I can't tell you whether I reviewed it or not. But I agree that if you're showing it to me and you tell me this is from them, yes.
Let me ask you about Joint Exhibit 1001. 3746.
Objection, Your Honor. Improper impeachment. It's not reading the second sentence right there that explains it.
Overruled. You can continue.
On Joint Exhibit 1001-3746, at the bottom, were you aware in reviewing the records that Mrs. Kowalski refused to have her child evaluated by psychiatry on admission? Were you aware of it?
Oh, yes, and I'm not surprised.
Were you also,
That's very appropriate.
were you, that you, so what you're telling this jury is you don't believe that Maya should have ever been assessed by a psychologist, true?
True, absolutely.
Okay, so let me ask you about her time in the hospital. Were you aware in reviewing the records that All Children's Hospital tried to transfer Maya to a comprehensive program for CRPS, but the parents refused?
Objection. No, that's no fact and evidence on any of that.
Okay, let me direct you to Joint Exhibit 1001-1765. Under projected discharge planning needs about halfway down. Placement, and I'll represent to you this is November 10th. Inpatient rehabilitation care, court order pending, parents declining to sign consent at this time. And then under provision of care, it says mother continues to deny consent for inpatient treatment at Nemours. Were you aware of that?
What's the question?
My question is, you've been critical of the care Maya received at All Children's. All Children's was trying to transfer her to a comprehensive center for,
Objection. This is
he asked me
not in
to,
evidence. None of these documents are in evidence.
this is the joint exhibit from All
Time
Children's.
out. Gentlemen, if you could approach.
All right, while they're sidebarring, I'll give you my golf speak. I'm trying to be quiet because people are sleeping. But this is crazy. I love this doctor's testimony. He's given it to the defense. The defense is trying everything they can to get him disqualified if somehow, get his testimony not credible, but they're not doing a good job. Yeah, this is my quiet golf voice. Dr. Chopra is walking to the third hole. The important things that we learned is that Johns Hopkins exacerbated her problems because they subjected her to stress. And stress is a trigger for CRPS. And I hope that she's doing okay with all the stress that a trial is, because that's a lot of stress.
The question is sustained, but you may continue, Mr. Shapiro.
Thank you, Your Honor. Doctor, were you aware during Maya's hospitalization that the parents declined to have her transferred to another hospital for care.
But,
Were you aware of it?
well, yes, according to what you're showing me on the document, yes, but I need to elaborate why they refused.
Okay, well, you're welcome to when Mr. Anderson asks you questions.
Actually, you can answer.
Okay, go ahead.
Finish the answer now.
Go ahead.
Well, because the idea of treating CRPS is first you've got to control the pain. You can't have a patient with severe burning pain in 4 limbs and you put them into an inpatient rehab center and start making them exercise. So ACH was not doing anything to help her pain. And so they need to control her pain, and then they would have transferred her to any other place they could. She was doing rehab anyway. She was even doing rehab at ACH.
Are you telling this jury that in your review of all the All Children's records, they never offered Maya anything for pain?
Not enough.
They offered Maya pain medication during her hospitalization. You know that.
But they didn't control the pain.
You are aware that, or are you aware whether there were attempts to transfer her for outpatient therapy? Are you aware?
Same objection.
Sorry, can you rephrase that question?
Are you aware of whether All Children's attempted to transfer or discharge Maya earlier in her hospitalization for outpatient therapy?
Well, I mean, you're not getting my point. My point is that All Children's did not control her pain. And now they're trying to pass her off to an inpatient rehab or an outpatient rehab or something like that. That's what they're doing. And parents didn't want that. Parents wanted a pain control, and they would have done the rehab happily by themselves. They were doing it at Dr. Hannah's place.
Okay, we talked about Dr. Hannah's records and their success rate, but let me ask you about your evaluation of Maya in your report. By the way, the recommendations you made in your, well, let me just back up. I apologize, doctor. You've seen Maya once for a forensic evaluation in January of 2017, correct?
Yes.
You have not evaluated her since, true?
No.
Okay. You sat with her for 5 hours and 22 minutes?
That's correct.
What pain medication did you give her for your evaluation?
No, it's just an evaluation, not a treatment.
Okay. She was able to tolerate your evaluation without any pain medication?
She wasn't. She was in severe pain.
She sat with you for 5 hours and 22 minutes, true?
She lay down. She didn't sit.
Let me ask you about some of your statements or plans of care. And actually, let me, I think this is Joint Exhibit 2005-1. Clay, if you don't mind putting it up on the screen, please. Well, I may have the wrong exhibit. It's there we go. I think this is what Mr. Anderson walked you through. True?
Yes, he did.
Okay. The way, and it's just a technicality, but I thought it was important to point out. So let me just ask you. This report that you have was actually a letter back to a primary care pediatrician, Dr. Wassenaar. True?
Yes.
Did you ever speak with Dr. Wassenaar?
No.
Let me ask you about some of the recommendations in your report. By the way, at this point, Maya hadn't walked in almost 2 years. True?
I don't remember that.
Okay.
For how long she hadn't walked.
I'm not trying to trap you, I promise. The testimony that the jury's heard is generally that after about July 4th, 2015, she was in a wheelchair from that point going forward. And if I got that wrong, I'm sure someone's going to jump up and tell me. But all that being said, so now we're 2015, 2016, so about a year and a half, she has not been out of a wheelchair walking. Okay. Would the lack of walking secondary to what you believe is CRPS cause her legs to be atrophied?
Yes.
Let me ask you about some of the recommendations that you were talking about with Mr. Anderson that begin, I think on page 18, it could be 19. So that's it. All of these recommendations are because Maya has CRPS, true?
No.
Well, I guess that's fair. Some of these are because you think she may have had Ehlers-Danlos syndrome, true?
Right.
That's a genetic disease.
Yes.
Did you test for it?
I did a clinical. There's no blood test for it. It's a clinical test.
Okay. Do you know if Dr. Wassenaar ever followed up on your letter to him recommending treatment for Ehlers-Danlos syndrome?
My job was very clear. The question I was asked was, does she have CRPS or not? And that was my job. My job was, I wasn't a treating physician.
I understand. You were serving as a forensic expert on this issue, true?
True.
Okay. But you did, in your evaluation of Maya, believe she may have had a genetic cause for some of her problems, true?
Could be.
And you also thought that she may have had a neurologic cause in the form of a tethered cord unrelated to CRPS.
I wasn't sure. I needed her to see a neurosurgeon to decide that.
Do you know if Dr. Wassenauer ever followed up with a neurosurgeon?
I don't know.
You also, in your report, if you go down a little bit on the same page, talked about bilateral thoracic outlet syndrome. Do you know if any follow-up was ever done for Maya regarding that?
We've already established that this was my one and only contact with Maya, and it is a forensic exam. So I'm not the treating physician. I don't follow up.
Okay. Then I promise you I won't belabor the question. The answer to any question I ask you of, do you know if Dr. Wassenauer ever followed up with this, any of this, the answer would be you don't know.
No, okay. I don't know.
And in terms of her complex regional pain syndrome number 11, it says minimize surgical trauma. At the bottom, 11A, minimize surgical trauma, including needle sticks. Okay. It was your belief at that time that Maya's CRPS was so bad that for going forward, she wouldn't be able to tolerate needle sticks. Is that true?
No, that's not what the recommendation means.
Okay, so and let me try to clarify. I appreciate that. In terms of what you're telling the jury, you don't know in the future whether Maya is going to have this problem because you haven't evaluated her. True?
We know she has CRPS. So this rule applies to her for the rest of her life. So a person can have CRPS in their left leg, and they still are at risk if they get a needle stick in their right arm.
Piercings, she'd be at risk if she got piercings.
That is a risk.
Okay. Do you know if Maya ever got piercings?
No, I don't know.
Do you know if she got piercings, whether she had any pain from them?
I don't know.
Okay. Do you know if she's had any subsequent surgeries where she's had any problems as a result of surgery, or you don't know?
So that's not how the human body works. So if you have CRPS and you get a piercing or you get a surgery, the chance of your CRPS getting worse or spreading is high, but doesn't mean that it will get high or it will spread.
So what you're telling this jury, you're not saying that these things on her list are more likely than not to happen. You're just saying that these things on your list are things that somebody, for example, with CRPS might encounter. Is that fair?
It's a standard recommendation for any patient with CRPS.
Got it. The recommendations on here are standard for anyone who has this diagnosis. True.
Recommendation 11A.
Okay. The just a couple more questions, Doc. Well, let me ask you a little bit about, you don't know how, I mean, I know she's in the courtroom, but you don't know physically how Maya's doing today, true?
No.
Okay, but you can tell physically she's doing better today than she was when she was brought into All Children's, true?
Well, first, I didn't see her when she went to All Children's. And today, all I've done is see her from a distance. That doesn't mean that she can't be in severe excruciating pain.
Has anybody, have you, in your time working on this case and working with Mr. Anderson, did you ever ask Mr. Anderson, how is Maya doing today?
No.
And when she saw you, she was in a wheelchair, right?
Yes.
And now she's walking today.
Yes.
One moment, please.
We are watching the Maya trial. It's me. I'm being quiet. I don't have to wake anyone up. And we're approaching again. This is my golf voice, my ASMR voice, trying not to wake anyone up. I love Dr. Chopra so far. I think his answers are great. I think he's a great witness. And I don't know what the defense can really do. Trying to make it sound like, oh, he's in it for the money, or, yeah, he was hired for his expertise. This is a guy you probably can't get an appointment with if you really want one. And boy, would I want one if I had a medically complex child. He's more than qualified. He's a Harvard professor. That award that he won for being the most compassionate doctor in the whole damn nation, it's like being a poet laureate in your craft. if I were sick, I would want to see a doctor like him. All right, I'll see if I can speed this up a little so we can get past this quickly. Let's move it to 2 times speed. Here we go. Hurry up, fellas. We don't have all night. And I don't want to wake up Mr. Fox. That would be bad. Oh my gosh, can you still hear me if I whisper? That's funny. It's a late night stream. Some of you are going to sleep. Go ahead. There won't be anything noisy. It's late. And I'm super cozy. It's like 50 degrees. I'm out on my porch. Archie Ruckus is running around out here, driving me crazy. Boy, this is a long one. Jeez, we're at 2 times the speed and they're still not done. The hell? Come on, boys. Hurry it up. What are we at? 6:26? Let's move. Here. All right, here we go. Oh, they're going on a break. What are they doing? Is the jury going in or out? I don't know.
Hey, jury, is that what everyone thinks is good? Mr. Shapiro, Mr. Anderson, does Dr. Chopra need to step outside, or can he sit here while you do what you do?
It's up to Dr. Chopra.
Oh, they're going to have a little mini hearing.
Yeah. Okay, why don't you come back in 5 minutes? Just remember, you can't talk to anybody about your testimony. Just so the court's aware, we're now talking about Exhibit 3035, and perhaps certain pages, including 0024. And we're going to wait on Mr. Shapiro to give us additional pages to look at. Do you want me to sit here, or do you want me to come back in 5 minutes?
You're welcome to come back in 5 minutes.
Okay, I'll be back in 5 minutes.
Okay, the judge is coming back in 5 minutes. All right, so let's skip ahead. Well, Judge, I went forward 5 minutes and you're still not back. All right, here we go.
We get into the DCF stuff.
Tell me specifically what pages we're talking about in Exhibit 3035.
3035-12 would be one of the ones that if we're going to go into this with this witness, I would want me to recross on.
12, and then what are the others?
3035-22 and 3035-23.
Okay, so can someone put up 12, 3035-12? And what is the objection, Mr. Anderson?
I think these are together, but if you look down under 3 p.m., Kathy stated parents are still in court reviewing patient's case with judge, and they do not anticipate meeting will conclude before 5 p.m. And my concern with this, Your Honor, is that I don't know what this witness is going to say once they open the door to the DCF matter, because I have not briefed him or prepped him, so he knows the rules. And so when we get into the DCF stuff, I think it's going to be the wild, wild west. And this is loaded with it, including, if you see the next page, judge would like appointment to be scheduled sometime tomorrow morning. We're going to be starting to try the DCF case too. So if you look at the next page.
Wait. I want to read this. I want to read it. Shit. Let me go back.
So,
I want to read it.
and they do not anticipate meeting will conclude.
All right, let's read this. We don't often get to read DCF documents. So let's see what it says. November 10th, 2016, 12:36 p.m. CM received a call from Kathy, SW from All Children's John Hopkins. So she's a All Children's SW. What does SW stand for? Some kind of, social worker. Per Kathy, she stated that a solid decision had not been provided. Judge would like to have a representative from Nemours to help answer questions related to the care of the patient, the care the patient would receive at Nemours, and the exact orders needed for transfer. Judge would like an appointment to be scheduled sometime tomorrow morning. CM contacted medical team regarding the above. Medical team agreed to join all children in a meeting via phone conference at their assigned location. Times proposed are 10:30 a.m. and 11 a.m. CM contacted Kathy with possible appointment times. Blah, blah, blah. All right. Received a call back. Jesus, this is what they do all day. It's maddening. Stated the parents are still in court reviewing the patient's case with the judge, and they do not anticipate the meeting will. And then my things are in here. Let's turn them off.
Before 5
oh,
p.m.
Stop. Where was I? Received a call back, reviewing patient's case with the judge. They don't anticipate the meeting will conclude before 5 p.m. Kathy stated there will not be a meeting tomorrow with the judge and stated that a meeting may in fact take place sometime last week. Okay, nothing terrific here, but I thought we might. I'm going to stop and read every DCF document I can because you don't know how rare it is to get these out in public. We never, ever, even as the media, get to see these documents. They keep them secret. Every single one. So getting them into court is probably huge, but even just us getting to see it is a big deal.
And my concern with this, Your Honor, is that I don't know what this witness is going to say once they open the door to the DCF matter, because I have not briefed him or prepped him, so he knows the rules. And so when we get into the DCF stuff, I think it's going to be the Wild Wild West. And this is loaded with it, including, if you see the next page, Judge would like appointment to be scheduled sometime tomorrow morning. We're going to be starting to try the DCF case too. So if you look at the next page, it's more clear.
Page 22.
Wait, they're going to start trying the DCF case? I thought that case settled. Did he just say they're going to start trying the DCF case? Okay, bizarre. And this one, unfortunately, is so blurry, I cannot read it. Oh my God, this is so frustrating.
So
You can't read this. Can anyone read this? I mean, I'm trying. Hold on. Let me see if I can see anything. No, this is so blurry. This is like, who took this document scan? A potato?
yeah, CPS has been contacted and is going to come to All Children's this afternoon to begin their investigation. I thought that what's the date of that? I thought that was out of evidence in terms of being used for cross-examination, but
Well, here's where I'm at right now, Mr. Anderson. Again, this is all predicated on what you're going to do with this witness. If I already told you, if you wanted to go into 3035-0024 with this witness, I'm going to let you do it. But so far, these other documents will probably come in so far. I mean, and yeah, there's some things in here that I'd rather not be, but you know, the Nemours issue probably is going to have to get explained somehow to the jury anyway.
well, it's fairly complex. And again, what happens if the witness who doesn't hear anything, doesn't know anything, starts telling what he knows about the DCF investigation, how unfair it was, all of the different things that we're alleging. I don't know what his knowledge is on that, Judge. And so it's very likely, I think, that we're going to get a lot more. This particular point here that they're trying to raise, I think, can be covered in other ways. But the main thrust of this is that they're getting DCF involved. It's the 9th. It's 2 days after they came in.
Well, again, this is predicated on what you're going to do. And you know, I'm not going to tell you how to try your case. It sounds like you don't need this witness to talk about the issue that you want to talk about. But hey, if you feel like you want this witness to make those comments, then I'm going to let you address the 0024 document. But on cross-examination, then I'm going to let them address at least 12 and 22. I haven't looked at 23 yet. So if you don't go there, then we don't need to make any rulings. If you do, then
Well,
we will. So it's up to you.
my biggest concern is I was hoping to have a couple extra hours this afternoon, which are rapidly evaporating.
Anderson is always telling the other side what he's worried about.
Well, there's a third one. I didn't look at
I haven't
23.
seen the third one either.
would be potentially 303.523. So that's one. You don't want- no, that's one. Okay, I guess not that one then.
Not 23?
We'll take that one.
I beg your pardon. We'll take 23.
Yeah, 303.523 would be the potential.
Yeah, we'll
Okay,
take 23.
Put 23
Can we
back
get
up,
those
please.
printed out somehow?
We'll take 23 as well.
I'd like to use a highlighter. We're kind of on a spur of the moment here. Do we have the ability to?
Okay, so let me be clear that because I'm gonna allow 3035-24, we're also gonna allow in 12, 22, and 23. Is that correct?
That appears to be it.
Mr. Shapiro, do you agree?
One moment. If I just get a proffer from the plaintiff of exactly what he plans to ask the doctor, only because the doctor said he doesn't know anything about the Moors. And so I'm trying to get a sense of how deep this is about to go and how we're responsible.
Well,
Because
let's-
obviously we don't want to open up.
Let's bring in the doctor, put him on the stand and see what happens
Okay.
outside the presence of the jury. Yes.
New Moors is a children's hospital, so it must be some records from another hospital.
Outside the presence of the jury, and we may or may not ask them again in front of the jury. Mr. Anderson.
May I please the court? Doctor, in your files, do you have the Nemours Hospital records? Do you know?
Look, I don't think I have. I'm not 100% sure.
Okay. If I showed you a particular Nemours document, then in evidence, do you think you can identify this as a Nemours transfer notice? Let me show. Can I show it to him?
Let's just put it on the screen.
Let's put it on.
My impression was that Nemours refused admission.
Exactly, but we were talking now about the reasons why.
And when you say put this document, you mean 3035-0024?
Yes, sir.
Can I have one of the IT folks put it up, please?
If you could read that, Doctor.
So this is just to save time, this is on Maya.
This was a Nemours. Rejected ultimately. And I wanted to ask you a question. I know I'm in the interest of time. Assume Jack and Beata Kowalski had research and determined that Nemours does not have a comprehensive CRPS program.
I object to this. This,
We don't have a jury. Let's get the information out first. Then you can talk to us about your objections.
This dude is pissed.
Again, Mr. Anderson, let's not make predicate statements. Let's just ask the questions.
Yes, sir. Assume Jack and Beata Kowalski had research and determined that Nemours did not have a comprehensive CRPS inpatient program. And assume further that the research revealed that it would be more of the PT that she had been through about 4 times. Assume further that from this form, as you can read, that the transfer to Nemours was based in part on Munchausen's by proxy assigned by Dr. Dees, who is not a psychiatrist or psychologist, let the record reflect. It says right there, pediatric hospitalist. And so do you have an opinion, assuming those facts, as to whether the actions of Jack and Beata Kowalski in rejecting the Johns Hopkins reasons and methods of transferring Maya to Nemours in Orlando?
I object to that question.
It's more proper.
I'm allowed to object.
This question, look, wait, I gotta stop. This question, you guys, this is the problem. Rob at Law and Lumber was talking about this. Greg Anderson can't ask a freaking question to save his life. That was a compound, hypothetical, 3-part question. Oh my God, I couldn't even repeat it if I tried. What is the question, Greg? No wonder this guy, the defense is objecting. He's got to stop. He needs to get the other associate who knows how to ask a question to get it out. I mean, it's ridiculous. He's killing this by not being able to ask direct fucking questions. What do you want to know, Greg? Tell me what you want to know and then tell the witness. Because, oh my God, if I'm the judge right now, I'm coming down there, I'm going to strangle you with your tie if you don't just ask the freaking question. Oh my God. This ASMR rant was brought to you today by Serpent Bite Whiskey.
The court asked the plaintiff not to give the predicate, and then he just gave 6 predicates. But in addition to that, he's asking now the plaintiff to speculate on the state of mind of the parents. He's not disclosed as an expert on either and judge the reasonableness of their conduct.
Okay, well, one thing I heard is you're now asking him an opinion. Sounds like this opinion wasn't disclosed. Is that correct?
He had no opinion about transfer availability.
Well, they were going to, I'm sure, open that door. I felt like they did on their cross. That's why I stood up.
Well, they opened up the door about Nemours. That doesn't mean this witness can give opinions that hadn't been previously addressed or disclosed.
I would.
If he had just asked a
I
direct
can't
fucking
remember the
question, this
specific
wouldn't have
2 or 3
happened.
questions, but my memory is that the questions were designed to give the jury the impression that somehow the Kowalskis had misbehaved or done something wrong in rejecting the Nemours transfer. That was clearly the thrust of them. To me, that opens the door for me to point out that they turned it down because it was based on, in part, Munchausen's by proxy. And I believe one of these codes here is from conversion disorder for Maya.
Why isn't this testimony from Mr. Kowalski?
It can be, but I think.
To me, I didn't realize you were going to ask him an opinion that had not been disclosed. So on that basis, no, this witness.
Okay, the judge should never have to tell you as a lawyer how to ask your question. This is embarrassing. Greg Anderson has 33 years of experience, supposedly. He's been a trial lawyer in over 100 trials, according to his website. How is it possible that the judge has to tell Greg how to ask a question? I mean, and who to ask it of? The judge really even shouldn't be doing this. He's telling Greg how to run his case. He's like, you need to tell Mr. Kowalski to get this testimony in. Why aren't you doing it with Mr. Kowalski? Why are you doing it with this? I can't even. This is embarrassing. It's embarrassing, Greg.
Can't testify to an undisclosed opinion.
Well, can he testify to anything having to do with his experience and the narrative provided affecting the treatment of the child and the family?
I don't understand your question.
Can I show him this? And he's obviously aware of the prior questioning, and ask him whether his experience would be that this transfer notice being signed by the Kowalskis, is it?
Time out. Sir, do you know anything about the possible transfer to Nemours?
All I know is that Nemours refused transfer.
Okay. How did you come to that information?
It's somewhere.
Oh my God. The judge has to ask the witness the questions himself because Greg can't get it together. I am dying, you guys. I am dying. The judge has had enough. He's like, oh my God, shut up. Let me do it because you can't get a question out to save your life. Why are they letting Greg Anderson question anybody? He's terrible at it. The judge has to do it for him.
In the records. That's the only way I would have known.
Do you know any of the details as to why the transfer was refused?
There was no details, but can I just put in something?
Sure.
If I were, as a physician and, with 30 years of experience, if I saw the word Munchausen by proxy, I don't want that patient.
Okay. Anything else?
That would probably be a pretty good question if allowed. Having seen the Nemours transfer notice, would you as a physician want to accept the patient? Answer, I gather, is no. And then I would ask him why.
I'm going to object to that as an undisclosed opinion. My questions to him about transfer were very specific to malpractice claims, meaning there was an allegation from Dr. Chopra that my client committed malpractice and not giving her the proper therapy. The only reason I was asking about transfer is part of the defense of that is All Children's tried to make a transfer of the patient to a center in Nemours that specializes in comprehensive regional pain syndrome and in the rehabilitation of that. And that was not consented to. It had nothing to do with his state of mind about whether mom should want this purely as a defense of malpractice claim, that very narrow issue.
Well, here's where I'm at. The issue of Nemours, I think the defense has opened that door, and you're going to be able to call whatever witness or witnesses to explain. It doesn't sound like, other than seeing some sort of reference in the records, he really has details as to what happened or didn't happen with respect to the proposed transfer. And so I don't think this is the witness for you to go into that.
I have a possible solution then. I'm happy to not go into this with this witness. If the court enters an instruction that strikes the 3 questions about the transfer to Nemours because they were asked before it was put into evidence.
Yeah, but there was testimony about it 2 days ago as well. So it's,
Well, I probably objected at that time too.
I don't recall. I really don't recall.
Well, our problem is this, Judge. If we're going into this, the jury should not be left hanging with this impression that Beata and Jack were being unreasonable. We have a right to rehabilitate, or whatever you want to call it, by pointing out that if they sign this, they're signing on to agreeing to Munchausen by proxy, among other things. And it's just not fair to our side that if the jury hears one side of that story, they won't hear the other side.
And again, I've said that you can call witnesses because the door has been opened. The reality is, I'm not going to allow in an undisclosed opinion. I think that's pretty clear. And it sounds like you're now trying to get him to make assumptions or assume a hypothetical to give an opinion that he has not previously given prior to today. That's no issue with Dr. Chopra, because I don't think this was something that was ever asked of him. So, you know, I told you earlier, if you're going to want to show this record, that's fine, but you can't ask him opinions that were undisclosed. And once you show that document, we're showing the other documents that we were talking about. So,
Well, you know, it really puts me in a dilemma.
You guys, wait, there's a car. Hold on. Ooh, traffic. Lots of traffic. What happened? Okay. What is that sign next to the judge? Why is there a sign of a person talking into something that does not look like a microphone? You know what it looks like. What the hell? What is that? Why is that sign there? I know we saw it the other day, but I thought it was at the witness stand to remind the witness to speak into the microphone, but that's not where it is. What the hell? Why is that on the judge's desk, you guys? Do you have any ideas? I'm sorry, but it looks so insane. What is that?
Here. And it's not a dilemma of my making. And the defense was allowed to ask questions of for a witness for documents that were not in evidence, thus leaving the jury with a certain impression. So if
Mr. Anderson, I just need you to decide.
We have 1 moment, Your Honor.
Well,
Literally 30 seconds.
I like this comment. Something's wrong with Anderson. Are we sure he's not a robot?
Dr.
No,
Chopra,
we are
I'm
not sure.
showing you exhibit 3035-0024. Do you have it in front of you?
Yes.
And does there appear to be a series of diagnoses in the middle of the page by a Dr. Dees, a pediatric hospitalist?
Yes.
And is one of the diagnoses assigned by Dr. Dees Munchausen by proxy?
Yes.
If you turn the page, is there?
I can turn it somebody else's.
That's all right. But there's a second page for a place to sign, which we'll bring up. And that's all I'll ask you. Was there a place where the Kowalskis were supposed to sign to agree to this for transfer? That's my own. Those are 3 factual questions.
There's no place for the patient or the patient's representative to sign.
Well, it says E-level, encounter E-level signatures, order level documents, and so forth. It's kind of in bureaucratese, but this is, I believe, what they were presented with.
he gave his answer.
All right, so I don't ask you about the signature page.
I don't know what encounter level e-signature means.
E-signature is one that's sent through the court. Yes.
He doesn't know.
Okay.
So
I
I'm
can
not
ask
gonna tell him for him to turn around and say it, so.
Well, I understand, Judge. I'd like to ask the factual questions here because I don't want the jury left with that impression. And it could be 4 or 5 days before we call Zach Kowalski.
If I understand, Mr. Anderson wants to address with Dr. Chopra the reasonableness of accepting transfer with a diagnosis of Munchausen in the record as an undisclosed opinion.
I think at this point, it's just the last 3 or 4 questions, the factual questions he asked about the document.
And the problem with that is the redirect, if the implication, I don't think this is a secret, if the implication is going to be that we would have accepted a transfer, except now that there's a diagnosis in the record, it's going to open up a redirect on the fact that it was also in the record in 40 other medical records and providers, from Lurie's to et cetera. I don't know how much of this I need to get in front of this witness. It's just.
That's a difference between a diagnosis and a theory.
Here's where I'm at. Those questions that you just asked Mr. Anderson, except for the parent signature question, I'm fine. I'm fine with the 0024 and 25. But if you go there, I'm going to allow 12, 22, and 23 as well. So I just need you to decide right here, right now, whether you're going to use this witness to do it, have this discussion, or you're going to call someone else down the road. And I know you feel like you're in a box, but at this point in time, you got to make a decision.
Well, over my objection, I probably at this point will hold off, with the document, but I will ask questions about the busy, the basis for transfer, because the basis for transfer in part was Munchausen by proxy.
Okay.
Is that okay?
If you're basically now going to ask them questions off of this document, I see that as the same thing as us introducing and showing the jury the document. So
That's pretty much the way I felt when on their
okay, Mr.
cross-examination.
Anderson, we are where we're at. Do you want to use this witness to talk about the Nemours issue as I just outlined, or are you not?
One moment.
He does not appear to know what he's doing. Like, I don't understand this. I mean, I can't tell you what I would do because I'm not a lawyer, so I don't know. But God, it's kind of embarrassing.
I don't know. It's very difficult. One more question of him and then
In proffer or
Proffer.
outside or with the jury?
proffer.
Okay.
Are you able to identify this as a transfer form as opposed to something else?
This is a report of an admitting nurse from Nemours.
Okay. And can you see from this document why we have an admitting nurse at Nemours giving this report?
Yeah, I would object to this speculation.
What kind of question
You
was
can answer the
that?
question.
What?
Sir, do you know the answer?
If you don't know,
What's
you
the
don't know.
question?
Yeah, the
Sorry.
question is, do you know why, and at this juncture, a transfer nurse was involved?
Well, yes, that I know. All children wanted to transfer Maya to Nemours
All right.
for rehabilitation.
And then what does the diagnosis in part show as a reason assigned by Dr. Dees to transfer her over?
It shows Munchausen by proxy.
And in your opinion, did this child have Munchausen by proxy? That is in the report and in the record.
Absolutely not.
Right. I'll use it.
Anything before I bring in the jury?
I don't think so.
So to be clear, at this point in time, and I'm not making this, but are we admitting 3035, 12, 22, 23, 24, and 25? Is that correct?
Yes, Your Honor.
I believe so.
Oh, wait. Keep going.
I hope to God they win this case in spite of Anderson,
There's a portion.
because it's not going to be because of him.
It does make reference to dependency court proceedings that I would like to redact before it gets admitted to evidence.
Well, again, I'm not fond of this entire exercise, but be that as it may, I feel like Johns Hopkins, by its questioning, has put the issue of Nemours squarely into contention here, and the plaintiff has a right to discuss that.
I don't believe that at this case. That's not the point. That's not the point of what I'm saying.
If that will draw the testimony, the attempted cross on something that was not in evidence, then I'm fine and we can go home.
Just for the record, I didn't question the doctor on a single record from the Moors. It was about the records from Children's Ordinance.
The testimony the testimony stands at this point. So the question is, and again, it's the same question I asked you 10 or 15 minutes ago. Are you going to want to use this witness to talk about those factual questions that we just were talking about and your opinion on Munchausen by proxy that you just elicited, or are you not?
How long do you plan to go today, Judge?
What can I do to get an answer out of you?
Oh my God.
I think
Oh, this is
So then my question is 12, 22, 23, 24, and 25. And now I'm hearing from Mr. Hunter that he has an objection to 25, which we should have probably told me 30 or 45 minutes ago. So
It's basically the bottom of 24, Judge.
can someone put up 24, please?
okay. Wait.
Wait.
Okay, we got to read this, you guys. This is one of those CPS or DCF records we never get to see, so I want to read it before it goes off the screen. All right. Requested all medical records for past 7 days and received packet from Dana, advised by Kathy, MSW, which I think is some kind of social worker. Patient's mom is not allowed to see patient. Patient's brother, age 9, and father have supervised visitation with patient by DCF. DCF trying to locate medical foster family in St. Pete area for discharge. Oh my God, they were going to put her in foster care? Oh my God. Please see note by S. Perez for further details. Oh my God, you guys, can you imagine being this family and they're going to put your kid in foster care? PT must have court order in place. Patient must have court order in place to be transferred to NCHIP rehab. Arrangements have been made by Lindsay, DCF worker, for this and are pending. Met with patient at bedside with S. Perez, social worker present, 10-year-old female with HX, what is that? I don't know. Diagnosis of complex regional pain syndrome, reflex sympathetic dystrophy, AOX3, whatever that means, in wheelchair, fully dressed with makeup on. Patient refused to wheel wheelchair towards couch to talk. Oh my God, you guys, her arms hurt. Her arms are in pain. She can't wheel the wheelchair. You heard the doctor say. So this social worker was trying to make her wheel herself to talk to her. These are these people, by the way, with superiority complexes, and they have a chip on their shoulder, and they treat everybody like shit. That's just the way they do it. This is DCF for you. Patient requested Sandra wheelchair to me, yet could clearly move arms to do so. She could move her arms. That doesn't mean that she could put the pressure on the wheels that it takes to roll over there. Oh my God. Oh my God. I want to slap this woman. She was in pain all over. Her disease was very complex and rare. She, I don't know what that says. She's something moving her legs. BL lower EXT muscle atrophy noted, and patient recoiled to touch. Patient refused to, and that's the end of the document. Here we go.
It makes reference to an order in place.
Just tell me the specific language that you're talking about.
Patient.
Patient must
Just
have
go ahead,
court order.
Judge. I'm sorry.
So the patient must have court order in place to be transferred? Yeah. Is that what you're talking about?
I was talking about the reference to court order, and there was one in here earlier. There was reference being made to the family being in court in front of the judge. and would not be available until the next morning. That was what I was really concerned about.
Is it any surprise to the jury that there were dependency court proceedings going on? And we're not trying that case, but
Okay, as long as that's understood, go ahead, Judge. I'm sorry.
so the court at this time, Madam Clerk, is going to receive 3035 pages 12, 22, 23, 24, and 25. And let's go ahead and bring in the jury.
All right, you guys. Well, that document we just read was really upsetting to me. So we have at least one confirmed instance where someone at DCF was trying to force her to do physical activity that would harm her and hurt her. And because she couldn't do it, they assumed that she was
Hey, everyone,
making
please
it
be
up.
seated. Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and you received no information. Is that all correct? And I want to confirm that since the last time you were with us, you were not approached by anyone about this case and that you have not seen any media coverage concerning this case. Okay. And I'll have to tell you, my wife always loves when I said it's 5 minutes. I seem to have a very elastic sense of time when it comes to 5 minutes. At least it wasn't one time I was with her and I said 5 minutes and 4 hours later I was still at the office working. So I apologize, but sometimes things just take a little bit longer. And I'm glad I didn't have you sit here while we were having that discussion. So
And you're still married.
I am still married, which is the biggest surprise of all. Mr. Anderson.
May it please the court.
The surprise
insofar
is that she
as
puts
the
up with that
specifics
tuft.
Of the day-to-day, month-to-month care of Maya Kowalski, would you defer to our physiatrist who has worked that out? Your opinion, would you defer to the physiatrist for the day-to-day minutia of the care?
I didn't, you'll have to rephrase it. I didn't get that question.
Don't worry about it. Okay. On cross, you were asked about an authoritative source, and I believe you answered that that it wasn't authoritative, and it might have been authoritative. But do you know if we can put up 1001 to 2718? Okay, I'm shifting gears because that's not the one I wanted, but.
Archie Ruckus just snuck up on me and started kissing my face.
Highlight the
Like really slow and sneaky.
the entire paragraph.
And suddenly there
just
was
the
a
top.
big dog face in
And
my
Can
face.
you read to yourself the reason why
And he just disappeared.
Beata Kowalski said she's not allowed to eat? What's a TPN?
It's called, TPN stands for parenteral nutrition. I forget the first T, what the T stands for, but it's nutrition that's given through an IV.
And is TPN a ban on feeding until the diagnosis could be understood by the hospital?
No, there's nothing wrong on giving TPN. I mean, there are some risks involved when you give someone TPN.
And did it come to your attention, though, that there was an order from Johns Hopkins that prohibited Maya from eating until they actually diagnosed what was wrong with her stomach?
Objection.
I wasn't aware of that rule, but that would be standard practice.
And so if this is standard practice and there was, in fact, such an order, would it be reasonable for Beata Kowalski to inform whatever the nurse was or whomever that Maya couldn't eat because there was an order saying not to eat?
Objection. It's lack of foundation. It's also speculation on state of mind.
Well, it says that Beata said that she is not allowed to eat, that she was just quoting the hospital orders, which the nurse should have known.
Yep. Okay. There was also a question about a tethered cord. Let me show you exhibit 1028-147. And I'll ask you there if we can highlight the line where he says the patient and father state she saw her GP. What's a GP?
General practitioner.
And so what's happening here? What does it show insofar as Jack Kowalski following up on the tethered cord recommendation you made?
He did follow up.
Let me show you then 2004-44. It's the MRI and Dr. Wassenauer's records. Now, there are no findings there of tethered cord, are there?
No.
Does it appear to you then that the Kowalskis followed up on your recommendation and found that now that they had the test results, there was no tethered cord?
There was no tethered cord. They did follow up on it. Yes.
You were asked on cross-examination about what was an authoritative source, and it was specifically the guidelines. I'm forgetting the phrase that they used. The consensus guidelines. Do you recall that testimony?
Well, I was reminded about it. Yes.
Okay. And you said you were aware of it. Does it show that Stephen Cohen is one of the authors of that?
Yes, he's the first author on it.
And tell the jury who Dr. Stephen Cohen works for.
John Hopkins, All Children's.
I moved to strike it as an accurate statement.
It's just Johns Hopkins.
You can overrule.
Thank you. All right. So now turning to whether or not the Kowalskis actually transferred or the reasons, let me show you what's been previously marked into evidence as 3035-0024. If we could bring that up.
I have it here.
All right. And so in this, does it appear to be from Nemours?
Okay, sorry. We're back. My computer. Elsie Merritt, so funny. At least you know what's going on because I've told you a million times. All right, here we go. Let's go.
The authors of that?
Yes, he's the first author on it.
And tell the jury who Dr. Stephen Cohen works for.
John Hopkins or Children's.
That's an objection to move to strike. I move to strike it as an inaccurate statement.
It's just Johns Hopkins.
You can overrule.
Thank you. All right. So now turning to whether or not the Kowalskis actually transferred or the reasons. Let me show you what's been previously marked into evidence as 3035-0024. You can bring that up.
I have it here.
All right. And so in this, does it appear to be from Nemours?
Yes.
And does it appear to be a transfer nurse that is creating the progress note?
So for the ladies and gentlemen of the jury, just want to explain. When a patient is transferred from one hospital to another, the second hospital sends over a nurse who does an assessment. And then based on the assessment, the second hospital will decide whether they want this patient or not. And that's this report.
So if you look at under Sandra Perez, MSW, and does it say that she met with the Johns Hopkins people?
She met with, yes, she did meet with them.
All right. Is one of the diagnoses already made and placed into this Munchausen by proxy?
Yes.
Doctor, what happens, and you previously discussed this, when a diagnosis like this is put into a patient's records?
I object to this.
She's already testified about narratives.
That question is sustained.
If I
Answer, I sustained it, so Mr. Anderson's going to have to ask you another question.
Okay.
What, if any, effect in your practice as a physician does having this Munchausen by proxy in the record?
I'm sustaining.
As opinion?
Yes.
All right. Well then, does it say that Johns Hopkins told them it was Munchausen by proxy
Objection.
among the,
Overruled the objection. You can ask that question.
does it say Munchausen by proxy is one of the diagnoses?
Okay, I have an opinion on this.
Please.
Can I say? Okay. For one, they
Object, Your Honor. Objection.
well, the jury needs to know the truth.
Sir, what I need is you to answer the specific question that was asked.
Okay.
Which I've now forgot.
The question that you'd asked was, is Munchausen? No.
What happens when? Well, that one's already been overruled. I said, was Munchausen by proxy assigned by a Dr. Dees with John?
Yes.
And did Maya have Munchausen, or did Beata have Munchausen by proxy?
No.
And is that a psychiatric diagnosis?
Yes.
Is it a negative psychiatric diagnosis?
Objection.
It's a grossly
Overruled. You can the answer stands.
it's a grossly negative psychiatric diagnosis.
All right. And so if you look at the bottom, does there appear to be some editorial about Maya with Johns Hopkins?
What do you mean by editorial?
Okay. Was there a comment made about whether or not she could clearly move her arms to do so?
Yes.
Right. And so in the actual diagnosis for the transfer, which the Kowalskis would have to consent to, obviously, was there a finding that was, in effect, an admission that if they signed, it would be Munchausen by proxy, they would agree to it?
Objection, Your Honor, and scope and foundation of relevance outside.
Mr. Court Reporter, can I have that question again, please?
Okay, and so in the actual diagnosis for the transfer, which the Kowalskis would have to consent to, obviously, was there a finding that was in effect an admission that if they assigned, it would be Munchausen by proxy? They would agree to it.
I'm going to overrule the objection. You can answer that question.
Yes.
I can say.
If the Kowalskis signed it, they would be admitting that they have Munchausen by proxy.
Thank you.
Is it defense turn?
Just very briefly.
Well, one last question. Was this transfer notice for the purpose of CRPS treatment or for a psychological psychiatric treatment?
Objection.
Sustained.
Nothing further.
Very briefly, Your Honor.
Yes.
Just because you were asked about Munchausen's and prior psychiatric diagnoses, are you aware of whether records prior to All Children's Hospital also contain those suspicions or diagnoses?
That's irrelevant.
I asked you if you were aware of whether other interns had also made those diagnoses or suspicions.
I'm just trying to think of the hospitals. No, not aware of any.
So the totality of the records that you reviewed and everything you reviewed, you don't remember ever seeing either at Tampa General or Lurie's Hospital prior to All Children's, their records containing their records containing either diagnoses or suspicions from other physicians about either Munchausen's or other psychiatric disorders. You don't remember ever seeing it.
Objection.
I know.
Because facts are not in evidence. No.
I don't recall any of them. Diagnosing.
That's all. Thank you, Doctor.
Anything further from the claims?
No, you're.
And
You didn't see.
you don't understand, the jury actually gets asked questions too.
Are you serious? It's a nice day.
Members of the jury, any of you have questions for the doctor? I see at least 1, 2, 3.
This jury loves to
Where's the
ask
support?
questions. Unfortunately, they're always really stupid. So we'll see. We'll see. I have moved from the porch to my bedroom, but I'm still being quiet because people are sleeping. It's late. It is
Let's, I know you're trying to conserve paper, but we
1 in the
enough paper for
morning
your notes.
here.
Just pull the whole sheet of paper, please. Thank you.
All right, what is this nonsense? Drex is on with Nick talking about suing someone for shaving him. Sounds like a problem that only single people have. That's what it sounds like. What? WTF is going on with LawTube? Well, I don't know, because I'm not part of LawTube. I'm LawTube adjacent, I guess. I'm a journalist. I'm not any part of that craziness, I guess. Oh. I'm so tired. I want to go to sleep. I have to get up at like, what time do I have to get up? 6:30, and it's 1 o'clock now. Let's move forward a little bit. 20, 26, 28.
Not at all.
Here we go.
How do you
Wait, let's go
simultaneously
back.
acknowledge this case?
Let's go
Pain
back.
in both her legs. And that was eventually
wait.
diagnosed as CRPS.
Hold on. They're conferring about the questions. That's what this is about. All right, I'm just going to speed it up to 2 times, and hopefully they'll figure it out soon. But I need to go to sleep soon. Okay, it's not that much longer, though. So we're going to get through it. What the hell, guys? Why can't I move this up? Hurry up. I think that sign is to remind lawyers to speak into the mic. It doesn't do any good, though, because they never do. They just stand there talking nowhere near the microphone. Meanwhile, all their papers and shit are the only things that pick up the microphone.
Yes, started.
There we
It's
go.
actually a very good question, and the answer is no, I don't know. What happened was she was admitted,
Wait.
and that was
We
before
missed the
this.
question. God dang it. I'm sorry, guys. This is so hard. All right, here we go. Here it comes.
Hey, Dr. Chopra, I have quite a few questions from the jury. Do you have an opinion on how Maya's CRPS started?
That's actually a very good question. And the answer is no, I don't know. What had happened was she was admitted, and that was before this case. She was admitted to the same hospital. She had been given very high doses of steroid for her asthma. And at that point, she developed pain in both her legs. And that was eventually diagnosed as CRPS, but we never could find out why. And that does happen in CRPS.
So the attorneys are aware, based on how he answered that question. I'm not going to ask the next follow-up on that.
Yes, sir.
The next question, is ketamine addictive physically or psychologically?
No, not at all. Not at all addictive.
Does ketamine cause constipation or continued use cause obstination?
No, not at all.
How do you simultaneously acknowledge this case is rare and unknown, but also answer that the treatment would have a certain outcome? What's the basis for your belief? Is it opinion or science?
I didn't understand that.
Okay. How do you simultaneously acknowledge this case is rare and unknown, but also answer that the treatment would have a certain outcome?
You mean case or the condition?
I think the question is case, but the attorneys and then the jury can follow up if I'm misunderstanding the question.
Well, I'll address both. CRPS is officially considered to be a rare condition, officially. But in reality, the incidence is actually very high. I have it here. It's about 200,000 cases per year, and the incidence is about 7% in children per year. It's officially considered rare because no one has gotten around to, because it gets missed all the time. So people haven't been able to accurately get figures as how many people actually have CRPS and was missed. This case of where a child developed CRPS and was accused of, parents were accused of child abuse, and then ending in mother's suicide is actually very common. It is worrisome, and it is extremely common, more than you would think.
The follow-up to that, what's the basis for your belief? Is it opinion or science?
Belief of what?
Your answer just immediately before.
Oh, no, these are all facts. It's not my belief. It's not a rare condition, but that's my belief. It's not a rare condition. And it's a general consensus also. It's just that we haven't gotten the data going. No one has bothered to collect the data. So it's still considered a rare condition. And a lot of people want it to remain as a patients want it to remain as a rare condition because the FDA then approves drugs easily for rare conditions. So a lot of people want that. And it's not, so it's my belief is it's not a rare condition, but the official statement is that. Any other beliefs?
Well, the next question
is,
and this is going back to ketamine, are there withdrawal side effects after long-term ketamine treatments?
No, not at all. No, you can be on ketamine continuously, and it happens. You can be on ketamine. Hospitals will put a patient on ketamine infusion continuously for 10 days, and then abruptly stop it, go home, and nothing, no withdrawal at all. That's the beauty of this drug.
And the last question at this time from the jury, is it more common for the onset of CRPS symptoms to gradually progress or to just appear one day with excruciating pain?
No. This condition, if you don't treat it, it's progressing, and eventually just keeps progressing till the patient doesn't get better on its own ever.
Plaintiffs, are there any follow-up questions?
Yes, Doctor, part of your review, were you able to determine whether in those instances where Maya went off ketamine, such as after Dr. Kirkpatrick, and before she went to Mexico, whether she ever experienced any withdrawal symptoms?
No, you don't get withdrawal from ketamine. I mean, she came back from Mexico and she didn't have withdrawal. No, you don't get withdrawal from ketamine.
And can you tell the jury, just so that when they're back there looking, what If it were to be withdrawal, if it was an opioid-like withdrawal, which I think is what they're thinking, what would you expect to see in her records?
Oh, she would have tremor, like any other withdrawal. She would have tremors and, what's it called? Feeling like bugs under your skin and all of those symptoms. Severe nausea, but yeah, severe nausea.
All right, and it's sort of similar to alcohol or nicotine or substance, any addictive substance?
Kind of.
But ketamine, is ketamine addictive?
Not at all.
Your witness. Oh, one more. Can ketamine, have you seen in your career asthma attacks cause CRPS?
No, there's no direct correlation in that. There may be an indirect correlation, but not a direct correlation.
Thank you.
I'm only going to owe you $1.
Is there a
One question, $1.
Is there a stop here? Do you have a button to put and push for stop?
I told you I'd pay you your $1. Yeah, it's gonna be quick, I promise. Just to follow up on one of the jurors' excellent questions, the side effects of ketamine, those include nausea, vomiting, colorful dreams, hallucinations, and headaches, correct?
Yes, but I need to elaborate on that. If you give someone a whole lot of ketamine suddenly, let's say I gave you 200 milligrams of ketamine as one shot, you would have all of those. You would be seeing pink elephants flying around this room. But if you give 200 milligrams over 4 hours, you'll be fine.
Okay, so high doses of ketamine would cause those side effects, correct?
Again, high doses of ketamine given slowly over time, well, you probably will not see that effect.
Those are the potential side effects of ketamine.
Those are the potential, yeah.
Okay, I owe you $3.
Oh, yeah, I know. And $4 there, $7 today. My day is done.
No other
Well,
questions?
members of the jury, do any of you have any further questions? None. May this witness be excused at this time.
I may hold him for potential recall later, but he may be dismissed today.
Okay. So, sir, what that means is you're free to go today. It's possible they might ask you back. So let's not talk about our testimony with anybody except for the lawyers, okay?
Okay. He hates me.
Thank you. Thank you for being here and have a good afternoon.
Thank you very much.
Okay.
Am I supposed to be first before
You can go right now.
Oh, cool.
And you might want to leave before we change our mind.
I know. One of these days.
Okay, I don't know if you see the last one from today. There's still some time left.
Okay.
There's like
Members of the jury,
an hour
let's take
left.
care of a few housekeeping items. That's going to be our last witness today. So I know it's
Oh.
only 4 o'clock and I'm sure you're really upset that we're leaving at 4 as opposed to 5. I know that there was a request earlier to kind of know what the schedule is. And I will tell you, I have been discussing that with the lawyers and I should be able to tell you tomorrow what our schedule is next week. And it's my intent, hopefully by the Friday of each week, to kind of give you a preview about what the following week's going to be and if we're going to have some time. When I say time off, it's really time off for the jury because there are other things that we are doing outside your presence. So when I say time off, don't assume that we're not working. I will tell you the logistics that go into a trial are extremely difficult. And before I was a judge, I was where these lawyers are. And you're balancing witnesses. They've got their own commitments and work. And that's before you even get to the life issues like, a plane, gets diverted or a delay or someone gets sick or, someone has to go to the hospital. I mean, there's just all the life issues that go on. So we kind of build into our schedule a little bit of time to account for that. The good thing for you right this second is we are a little bit ahead of our schedule. So I'm constantly discussing with the lawyers, usually it's outside your presence, where we are, what witnesses we have going on. And the lawyers on both sides are working very hard to coordinate what witnesses are going to be here. So everybody knows when you walk through the door that we are asking witnesses questions and everyone is prepared. And so, the lawyers have done a very good job on both sides to do that. So I know that there is a desire for a schedule and I will accommodate as best we can. Understand also that there are
issues that sometimes crop up that, what will I know tomorrow might not be the same as what I know next Wednesday. And so I will do my best each Friday, if not before then, to kind of give you what the following week's preview is. Is that level of frequency sufficient for you all, or do I need to have a more rapid? Okay, I promise you that I will do that. And I do see, sure.
All right, it looks like they're just going to talk about scheduling. So I think we're done here for tonight. Thank you so much for being here and for doing this chill stream with me. And I loved this, actually. I thought we did a really good job just typing back and forth. And my golf voice, my ASMR voice, we did it. We got through day 5 on the same day. So it's working out. And I'm still going to work and covering the trial. Who knew? So I will see you guys tomorrow. I'm probably going to stream a little bit of it tomorrow before I go to work. I do have to be at work in the afternoon, so we'll probably do something similar to what we did today. I kind of liked cooking while doing the stream, so I wasn't sitting on my ass getting numb, which I can't sit for that long. It's too hard. So maybe I'll come up with something else to make tomorrow. So you're just going to have to tune in to find out what it is. And I'm going to have to think about it because I don't know what I want to make. Maybe we'll do maybe we'll do chicken soup. I have the stuff for chicken soup. I don't know. We'll find out. All right, guys. Good night. Have a lovely night. I hope that you sleep really well. I'm going to bed.